So here's the question. Can a new federal law mandate the detention of thousands of non-citizens before they're even convicted of a crime?
And at the same time, yeah, it requires something like $83 billion in resources that haven't been budgeted for.
It sounds impossible.
Yeah.
But that is the core tension we're looking at today in our deep dive on the Laken Riley Act.
Or the LRA, yeah. It's a piece of federal law that has, it's just completely rewired the operating manual for immigration enforcement in the U.S., and it did it so fast.
And the law itself is named, of course, for the tragic case of Laken Riley, the Georgia student.
Yeah.
She was murdered by an illegal immigrant who, and the sources confirm this, had been arrested for theft before and then released.
Right. And the political response to that was immediate. The legislation that came out of it, signed in early 2025, was incredibly aggressive.
Aggressive is the right word. The enforcement data we have just backs that up completely.
It really does. Since the law took effect, we've seen this massive surge. As of, late December 2025, more than 17,500 illegal aliens have been detained under these new LRA rules.
That kind of speed is it's unprecedented. And it's because the whole legal threshold changed.
Yeah.
I think that's the critical piece for you to understand here.
It is.
Detention is no longer about a conviction. Now, it can be triggered if a non-citizen is simply charged with a crime, or even just arrested.
Which creates this immediate, undeniable enforcement impact. But that success, if you want to call it that, comes with a huge catch.
A catastrophic one.
Yes. That level of enforcement, according to official projections, carries an estimated price tag of $83 billion.
Over just 3 years.
Over just 3 years. And the most just astonishing fact in this whole stack of sources is that the bill itself provided exactly $0 to pay for it.
Not a cent. So IC, Immigration and Customs Enforcement, they looked at this and basically said, what?
They concluded that executing the law is, and this is a quote, impossible with existing resources.
So you have this political mandate that's working, right? It's generating thousands of detentions. It's doing what it was designed to do.
But it's tied to a financial crisis that could sink the whole agency that's supposed to be implementing it.
Okay, let's unpack this. We have a powerful, actively enforced law, but the money just isn't there. So what does this law actually mandate, and how did it create this immediate clash between enforcement and resources?
Well, the LRA's mission at its core was really to strip away discretion, administrative discretion. Before this law, I see officers had some leeway. They could use their judgment on whether to detain someone who is pending removal, especially for a minor offense. The LRA just gets rid of that wiggle room.
So who is this new mandatory net actually designed to catch?
It's targeting non-citizens who are classified as inadmissible, and this is a really crucial distinction. We're talking about individuals who, say, entered the country without inspection, maybe overstayed a visa, or just don't have valid entry documents. Generally, this law doesn't really affect lawful permanent residents.
Yes, like green card holders.
Right. They're under a different set of rules. The focus here is squarely on people with the weakest legal claim to be in the U.S.
But the real, you called it a seismic shift, is this move away from needing a conviction, from a judge finding guilt. That changes everything.
It changes absolutely everything. Historically, mandatory detention, where you can't get out on bond, that was for people convicted of serious crimes. Felonies.
Right.
Now, that mandatory detention trigger gets pulled if an inadmissible non-citizen meets any one of these 4 criteria. They can be charged with an offense, arrested for an offense, convicted of it, or even just admit to committing the basic elements of the crime.
Let's just focus on the first 2, an arrest or a charge.
Yeah.
So, wait, we're talking about someone being detained, maybe indefinitely, with no chance for a bond hearing, before a prosecutor has even gotten an indictment.
That's the mechanism. And that's exactly why critics immediately started raising alarms about due process.
Because you can't bond out.
You can't bond out. Once you're detained under this provision, you're just stuck in detention until your removal case is over. Weeks, months, however long it takes. There's no path to temporary freedom while you fight your case.
And what specific crimes are we talking about here? It wasn't just for major felonies, right?
No, not at all. The law casts a really wide net. It explicitly lists certain crimes, and it leans heavily on property crimes. So things like burglary, larceny, theft, and even shoplifting. Shoplifting. And beyond that, it includes assault on a law enforcement officer and any crime that results in death or serious bodily injury, which could cover certain DUIs.
That list, especially with the property crimes, that covers a huge amount of conduct that might be a misdemeanor in one state, but something more serious in another.
And that's where it gets incredibly complicated for federal agents. The definition of shoplifting or burglary, that's not a federal definition.
It's state by state.
It's determined by the laws of the specific state or even the local town where it happened. So an ICE officer has to be an expert on the criminal codes of every single jurisdiction to know if an arrest even qualifies under the LRA. It's a legal headache.
Okay, so given this really broad legal threshold where just getting arrested can land you in mandatory federal detention, what does the data actually show? How fast is ICE using this new power?
The speed is, it's undeniable. DHS launched this thing called Operation Angel's Honor pretty much right after the law passed.
A nationwide operation.
A nationwide operation specifically targeting LRA offenders. And like we said, we already know that over 17,500 non-citizens were detained under the act by the end of 2025. That shows you they put massive resources into it right away.
And the examples they gave of who they caught in that operation, they really illustrate the kind of net they're casting.
Absolutely. They highlighted cases like Sergio Luis Hernandez Gonzalez from Cuba, a repeat offender convicted of 17 counts of larceny, selling cocaine, vehicle theft. I mean, this is clearly the kind of serious criminal the public wanted detained.
We also see Yazer Garcia Ramirez from the Dominican Republic, who is facing serious pending charges for conspiracy to distribute heroin and domestic violence.
Right, or Santos Chimdiego from Guatemala. He had prior convictions for assaulting an officer, DUI, and child cruelty. So these examples, they show the rules are working to detain people with pretty severe criminal histories.
But it's the North Carolina data that really shows how the focus of enforcement shifted, not just the raw numbers.
That data is so key. It's a perfect before and after snapshot. So IC arrests in North Carolina, they basically doubled in 2025 compared to 2024, jumped from about 1,700 to 3,400.
So that's the volume. But who they were arresting, that's what changed even more.
Precisely. Before the law, in 2024, about 67% of the people IC arrested were already convicted criminals. Since the LRA took effect, that number has dropped sharply, down to 46%.
So if the share of convicted criminals went down, that means the huge increase had to come from this new group, the people who were just accused.
The numbers confirm it. Arrests of people with only pending charges, so no conviction yet. They didn't just go up a little. They shot up by nearly 300%. From about 250 in 2024 to over 1,200 in 2025.
Wow.
It just shows the LRA is incredibly effective at its stated goal: detaining non-citizens based on accusation and shifting enforcement from post-conviction to pre-trial.
And that brings us right back to the central paradox here. We've established the LRA is fast, it's effective at detaining people, but that leads straight into this operational and financial chasm.
Yeah.
You can mandate detention, but you still need that $83 billion to house everybody.
And that money has to come from somewhere, and Congress didn't provide it. The logistics alone are staggering. To comply, ICE would need an additional 118,500 detention beds.
That's more than doubling the entire national capacity.
It is. Plus, they need more staff for enforcement, processing, everything.
And ICE's official assessment was that the bill is impossible to execute. This isn't just, bureaucratic complaining. This is the agency saying a federal law has made them functionally insolvent.
It is the definition of an unfunded mandate taken to an absolute extreme. I mean, think about that analogy one of the sources used.
The library one.
The library one. Imagine a city council passes a law saying the public library has to be open 24/7 and double its book collection, but then they refuse to give it any more money for the books or the electricity or the overnight staff. The mandate exists, but you can't actually sustain it.
So is the implication here that Congress basically set ICE up to fail, forcing them to prioritize the political win, the immediate arrests, over any kind of sustainable long-term enforcement?
That is the critical implication. These short-term enforcement bursts, they look great. But without the funding, the whole system is permanently strained. It forces officials to make these impossible triage decisions.
Deciding who they have to let go.
Exactly. Which dangerous person do we have to release to make a bed for the next person who is a mandatory detention?
And that strain leads right into the big due process argument. If the system is totally overwhelmed and it's detaining people based on an arrest alone, what happens to the person who's eventually found innocent?
That's the flashpoint. Critics, legal groups, some members of Congress, they argue that mandatory detention for just an arrest without a bond hearing creates an unacceptable risk.
For sure.
An inadmissible non-citizen could be arrested for, say, misdemeanor shoplifting. They get detained for 6 months waiting for their immigration hearing, and then they're found innocent in criminal court. But they still lost 6 months of their life.
And probably lost their immigration case in the meantime because they couldn't fight it effectively from inside detention.
It accelerates the removal process by taking away their ability to fight from the outside. And critics point out that this wide net has swept up a lot of people who are not the worst of the worst.
There was that data from TRC.
Yeah, the Transactional Records Access Clearinghouse. They estimated that as of June 2025, 44% of people in ICE detention had no criminal record at all, other than for entering the U.S. illegally.
44%. I mean, that statistic is a really powerful counter-narrative to the law's stated purpose, right?
It is.
The Laken Riley Act was passed to target serious, violent offenders. But the data suggests a huge portion of the detentions are focused on the technical violation of just being in the country illegally.
And that shift in focus is what gives critics their ammunition. When your resources are already stretched so thin, aggressively detaining non-criminals means you're spending billions that could have been used to find and remove actual violent offenders.
Yeah.
It's a resource paradox.
Okay, and let's touch on this last part, the state standing provision, because this feels like a really fascinating structural change to the whole federal-state dynamic.
It's fascinating, and it's a huge deal. The Act basically tries to alter the balance of power. It gives state attorneys general the right to sue the federal government, specifically DHS, if they feel it's failing to enforce these new mandatory detention rules.
So a state can believe the federal government isn't doing enough, and they can actually take them to court to try and force their hand.
Exactly. It's this unprecedented tool for states to try and exert leverage over federal policy. But what it really does is open the door to constant politically charged lawsuits, which just adds another layer of cost and burden to an already impossible mandate.
It turns the immigration fight into a permanent courtroom battle.
A perpetual one between the states and the federal government.
So what does this all mean for you, the listener? We have this aggressive, enforceable law that has absolutely resulted in tens of thousands of detentions, often based on just an accusation. It's fulfilling a major political promise.
The data shows a clear, dramatic shift. They are targeting people with pending charges, not just those with proven convictions.
But that same very effective law is tied to an $83 billion funding hole and this fierce debate over whether mandatory detention based on arrest alone is, just...
It's a system designed for maximum enforcement, but with minimum sustainability. The LRA represents this huge expansion of federal power to detain based on suspicion, not proof, and it's straining logistics and legal precedent at the exact same time.
So here's the thought for you to carry forward. If a federal law dictates mandatory costly detention and gets undeniable enforcement results, but Congress refuses to pay for it, does that create a real national solution? Or does it just create an expensive obligation that local communities and state governments now have to fight over and ultimately absorb the costs and consequences of?